Alors, bonjour, bienvenue. Merci d'être ici à cette présentation spéciale. En fait, mon nom est Éric Hamelin, je suis professeur ici au département de fiscalité de l'Université de Sherbrooke. Et vous êtes présentement, j'ai mes étudiants dans la salle, certains à Sherbrooke, mais plusieurs personnes en ligne. Vous êtes présentement dans mon cours de fiscalité prise de décision, puis à 716, une séance spéciale aujourd'hui. Donc, bienvenue à mes étudiants d'un jour. Aujourd'hui, comme vous savez, donc, on a le privilège d'accueillir avec nous M. Brian Arnold, le professeur Brian Arnold, qui va nous faire une présentation sur la règle générale anti-évitement. Avant de lui céder la parole, simplement vous rappeler un peu qui est le professeur Arnold. D'abord, c'est un gradué en droit de l'Université Harvard aux États-Unis. C'est un professeur, évidemment, qui a enseigné à plusieurs endroits dans le monde, dont à Harvard, bien sûr, mais aussi à l'Université de New York, Sydney, Melbourne en Australie, et plusieurs universités canadiennes. Mais c'est aussi un expert en fiscalité, je dirais, générale, mais surtout internationale. Vous avez, le professeur Arnold, été consulté, vous avez conseillé plusieurs gouvernements, les Nations Unies, entre autres, l'OCDE. Et un de ces mandats de consultation qui nous concerne plus aujourd'hui aussi, c'est que le professeur Arnold était avec l'équipe du ministère des Finances en 1987-88, quand la règle générale anti-évitement a été mise en place. Il faisait partie des experts qui a aidé le gouvernement fédéral à mettre en place cette règle-là et évidemment le suivi jusqu'à maintenant. Et actuellement, le professeur Arnold est conseiller spécial au sein de la Fondation canadienne de fiscalité et a un fameux blog, mais un bulletin qui est publié sur le site de la Fondation canadienne de fiscalité, qui est le Arnold Report, qui est publié à peu près aux 2 semaines et qui est beaucoup lu dans la communauté fiscale. Alors, on est choyé d'avoir avec nous le professeur Arnold. La conférence aujourd'hui se déroulera en anglais. Alors, si vous me permettez, je vais tout de suite commencer mon introduction en anglais pour présenter le professeur Arnold. So, welcome, Professor Arnold, to in my class today. It's an honor for my students and for me to have you here at this specific moment in time. We know that GAR is a very important provision in the Canadian income tax system. But right now, it's a specific time for GAR since its beginning, it's the first, I would say, major review of this provision that is done by the federal proposal that were tabled back in March of this year, and also we had a few weeks ago the first major tax cases. I mean, the first Supreme Court decision on the GAR since Copthorne Holdings in 2011. I mean, the first decision regarding the application of the Income Tax Act. Alta Energy was about tax treaty. So it's a pretty important case. So we are very fortunate to have you here today to talk with us about, to share your thought about this proposal from the federal government and Dean's Knight decision. So without further ado, Professor Brian Arnold.
Thank you very much for that kind introduction. And it's my pleasure to be here. I will be anywhere to talk about tax. This is my life, and so it's a huge pleasure. What we've heard since the decision in Dean's Knight from a lot of tax practitioners is that it's a disaster. That tax planning as we know it will never be the same if it will be possible at all. And my job today is to explain to you why that is not the case. And so I'm going to be telling you that Dean's Knight is pretty much consistent with previous Supreme Court cases dealing with the GAR. It does I think, deal quite nicely with some ancillary elements, but it's not going to have a huge impact, significant change on what we do. So on this first slide is what I'm going to talk about. And if we have time, the last thing there is, of course, the proposed amendments to the GAR, and that have some relevance to some of the things in Dean's Night. So here's just some of what I think are outstanding issues with respect to the GAR, right? That previous cases have not settled these issues. The question of tax attributes, that has been settled by a specific amendment in 2022. And so I'm not going to talk about that. There's an issue with respect to what the purpose test is in the definition of avoidance transaction. And there's an amendment proposed to change it from a primary purpose test, which it is now, to a one of the main purposes test. Series of transactions is an ongoing troublesome issue with respect to the GAR, and there's nothing in Dean's Night or in the proposed amendments to deal with that. And then you can see there are some issues like the relationship between the Duke of Westminster principle, which I'm sure you all know, which is taxpayers have the right to arrange their affairs so as to minimize the amount of tax payable. What's the relationship between that principle and the GAR, right? We've had the Supreme Court since Canada Trust Code telling us that taxpayers have the right to certainty, predictability, and fairness. I'm sick and tired of hearing that phrase. What's the relationship between that principle and the GAR? And then, of course, Dean's Night raises this question that has been plaguing the GAR since the beginning. What's the relationship between the GAR and a specific anti-avoidance rule in the GAR? Does the GAR apply to supplement that rule or not? That's an issue that was confronted in Dean's Night, of course. And then another issue that is raised in the Dean's Night case, and I think is just here to plague those of you who are young. This will be around for the next 50 years, and courts are going to struggle with it. And that is, what's the difference between an ordinary exercise in interpretation and the interpretive exercise that takes place under that first step in a GAR abuse analysis? What's the relationship between those two things? Right. And then the rule of economic substance is, of course, an important thing that is going to be dealt with in the amendments. Now, I'm not going to spend long on facts in Dean's Night, just because it's a complicated transaction. We could spend the entire time talking about what the deal was. But basically, you've got a company, it's got $90 million of losses. Now, it's not just losses, it's ITCs, it's scientific and research credits. And of course, what do they want to do? They want to monetize them. That's what it's all about. Now, you can call this a corporate restart, if you like euphemisms, or as one of my friends in the CRA calls it, a corporate head start. Because of the use of the losses. So they enter into an arrangement, a complicated arrangement with an investment venture capital firm. And what they do is they sell all their business assets to Newco, right? The investment company, MAPCO it's called, it pays $3 to $4 million for debentures, right? The debenture is convertible into 35% of the voting shares, right? Not 51% of the voting shares. It's less than 51%. And they get 79% of the total equity through non-voting shares. So the only thing that the company has left is it has its losses. That's all it has, right? And then the venture capital firm goes out and it converts its shares. It goes out, it finds some new investors, it finds a new business, it's a bond trading business, right? And that's what they do. And what do the new shareholders benefit from then? Well, they've got the losses in this company that they're going to deduct against the profits from the bond trading business. So that they're in effect earning tax-free income as a result. And of course, there are all kinds of provisions in that investment agreement that basically mean that Dean's Knight can't do anything without Matco's approval. And we could go through all of that, and it's detailed in the case. So the issue in the case is quite simply this section 111.5, has it been abused? And you can see what 111.5 says. Where control has been acquired, right, and the losses get restricted to being deducted against the same business that gave rise to the losses. Okay. Case law has said control means de jure control, right? The ownership of 50 plus 1% of the votes in the election of the board of directors of the company. So that's pretty straightforward. Everybody seems to assume here that this transaction complied with 111.5. So it goes through the courts. Tax court says GAR doesn't apply, it's not abusive. Federal Court of Appeal reverses and says it is abusive. The GAR applies, and it goes to the Supreme Court on that narrow issue of is it abusive? And the Supreme Court basically decides that in a 7-1 decision with Justice Cote dissenting, it decides that the GAR applies. Justice Brown, by the way, participated in the hearing of the case, did not participate in the decision because his position on the court was under question. He has since resigned from the court. Okay? Very likely, I think, judging if anybody watched the hearing from the questions that Justice Brown asked, I mean, he would have dissented along with Justice Cote. Okay, so let's just look at what the majority, written by Justice Rowe, starts out with a description of the background to the GAR. I mean, wasn't absolutely necessary, but my own view is Justice Rowe probably wants this decision to become the decisive GAR decision, and therefore he's trying to make it as complete as he can. And then he turns to a discussion of these issues involving the GAR, the relationship between the GAR and the Duke of Westminster principle, and this certainty, predictability, and fairness mantra, as I call it. And what does he say? Well, he says that the Duke is attenuated by the GAR. Now, I'm not sure what he means by that, that the Duke is attenuated by the GAR. It would have been much better, in my view, for him to recognize that the Duke of Westminster principle is simply irrelevant. It's certainly irrelevant with respect to GAR analysis, but for my own view, it's totally irrelevant in any case in this situation. What does the Duke of Westminster principle say? It says you can arrange your affairs to minimize the amount of tax payable within the law. What's the law? Well, the law is what you read in the provisions of the Income Tax Act plus the GAR. So why are we talking about the GAR? It just doesn't make any sense. And by the way, you should know that the courts in the United Kingdom, right, the House of Lords, that created the Duke of Westminster principle, that basically said what I just summarized. The Duke of Westminster principle is irrelevant. Right? but the Duke has simply immigrated from the UK to Canada, living happily under the protection of the Supreme Court. And the Duke's principle is just attenuated, right? Which makes it seem like the GAR is an exception to the Duke, right? But it really isn't. And then Justice Rowe, in contrast to Justice Cote, says, yes, the GAR creates some uncertainty. Obviously, it does. Any anti-avoidance rule creates some uncertainty. But it just applies to people who try and drain the last drop of beer from the beer glass. Right? And it's not what Justice Cote says, the GAR will be relevant in every case that involves tax avoidance. That's just, I think, a little bit of hyperbole. So, having said, right, that dealt with the GAR and the Duke of Westminster principle, he turns his attention to the mantra of certainty, predictability, and fairness. Now, you have to understand here, if you go back and read Alta Energy, in the first paragraph of Alta Energy, what Justice Cote, who wrote that decision, says is that the Duke of Westminster principle and taxpayers' right to certainty, predictability, and fairness are the bedrock of Canadian income tax law. And I'm ashamed to admit that she quoted something that I wrote in support of that principle, right? In fact, what I wrote was, the Supreme Court has said on many occasions that the Duke of Westminster principle is the bedrock. It's not me saying that. I was not saying that. I was saying that they've said it, right? But it's quoted as if that's what I was saying, right? So what he basically says in this case, and remember, this is only like less than a year and a half later. The Supreme Court says, no, certainty, predictability, and fairness, that mantra, that doesn't play an independent role. That is simply something that Parliament has embedded in the GAR. When Parliament decided on the GAR, it took into account, right, certainty, predictability for taxpayers, and fairness for the rest of us. So hopefully what this will do is this will put an end to courts just intoning this mantra and expecting to win, right? And hopefully it will put an end to tax litigators just arguing this mantra and expecting that they should win. This is not a substitute for thinking about how the GAR applies to transactions. Question, though, I raise is it still, does this just mean with respect to the GAR? And this mantra is still applicable with respect to non-GAR cases? That's an open issue. Okay, and to me, right, Justice Rowe repeats what was said in Copthorne. GAR involves the unusual duty of going behind the words of the legislation. And I ask you, well, what's unusual about that? The Supreme Court has said that all legislation, including tax legislation, is interpreted, right, in a textual, contextual, and purposive manner. So, context and purpose, what do they require you to do? They require you to go behind the words of the legislation. Right? Context involves extrinsic aids, external context. Right? Purpose certainly involves, right, the purpose of the provision, extrinsic aids. So I never understood this. I don't understand why they're repeating it. And then he says, he confirms the two-step approach to abuse analysis. First step, you determine the object, spirit, and purpose or underlying rationale of the provisions. And then the second step is you've got to determine whether the transaction in question frustrates, contravenes, abuses, defeats, whatever word you want to use, that object, spirit, and purpose. And that's why I think this is not a revolutionary change in the application of the GAR, because what Justice Rowe has done is simply confirm a basic approach to GAR cases. So what he basically does in terms of arguments to support this is he distinguishes between the rationale of the provision, that's the why, if you will, and the means Parliament chose to reflect that rationale. So it's the why and the how, right, are the two different things. To me, all he's done is he has simply provided different terms to describe the tension that has existed from the beginning of the GAR, and that's the tension between the text of a provision and the purpose of the provision. And that tension, right, is, you can describe it in terms of the why and the how, but it's just, what does the provision say? And what's the purpose, the underlying rationale of the provision? He also clarifies that the GAR can apply to both foreseen and unforeseen abuses. And that's worth a moment's comment, because this is something that the Supreme Court in Alta Energy said the GAR applies to unforeseen tax strategies, right? Not to ones that are foreseen. They make an explicit statement to that effect. Now they're changing it. You can see why I don't say this is a revolutionary. I mean, they could change next case, right? Take a flip-flop. So here they say, no, it can apply to both foreseen and unforeseen. There is a proposed addition to the preamble, the proposed preamble to the GAR, that's going to say that explicitly. But it should not be necessary to say that. If you look at the history of the GAR, right, and I dare say nobody listening to this presentation was probably around at the time that the GAR was introduced, other than me. But I can tell you, one of the things that happened when the GAR was introduced is that a number of specific anti-avoidance rules were eliminated. So, for example, there was a provision against surplus stripping in 47(1). It was repealed when the GAR came in. You know why? It's because the government said, we don't need it anymore. Why? Because we've got the GAR. Now, how can you say that the GAR only applies to unforeseen tax strategies when they eliminated a provision that dealt with a clearly understood practice of surplus stripping? It just doesn't make any sense to say that. And there were a bunch of other specific anti-avoidance rules that were eliminated as well. This next one is the one that I indicated is a difficult issue. So what Justice Rowe does is he endorses what Justice Rothstein said in Copthorne. And I'm just going to jump. This is what Justice Rothstein said in Copthorne. So the difficulty here is, and this has existed and caused some of us who were involved in the in the GAR some consternation is that the GAR is a provision of last resort. So what do you do before you ever get to the GAR? You have to interpret and apply all the other provisions of the Act. How do you do that? TCP, textual, contextual, and purpose analysis of those provisions. Now you get to the GAR. In other words, you've concluded this transaction complies with all the provisions of the GAR, of the Act. Now we turn to the GAR. What's the first step of the abuse analysis? It's an interpretive exercise. But wait a minute, you've already interpreted those provisions. Now what do? You do it again. What do you do the second time? You do it with feeling. You know, like I'm not sure what's going on there. But you do that interpretive exercise under the GAR. It's one of the really unique features of the GAR. Most exemptions or exceptions in provisions are substantive exceptions. You know, this provision does not apply unless a company has sales in excess of $10 million. That's an exception. But abuse and misuse, you know, the GAR doesn't apply unless there's a misuse or an abuse having regard to the provisions of the Act as a whole. I mean, that's an exception, but it's an exception that is based on an interpretation of the provisions to determine their object, spirit, and purpose. So it raises this question of, right, what are you doing differently when you do that analysis under the GAR as opposed to what you do ordinarily when you're interpreting the provisions of the Act other than the GAR? And Justice Rothstein tries to explain this, right? So he says, in the traditional statutory interpretation approach, the court applies the TCP analysis to determine what the words mean. Fair enough, I can understand that. In a GAR analysis, the TCP analysis is employed to determine the object, spirit, or purpose of a provision. So what he's telling us is, you use the same TCP approach to determine two different things. In the one case, you're determining what the words mean. In the second case, you're not determining what the words mean, because you already know that, presumably. But what are you determining? You're determining the object, spirit, or purpose of a provision. What I have difficulty with is you're applying textual, contextual, and purpose of analysis to determine the object, spirit, or purpose of the provision. In other words, to put it simply, you're applying TCP to determine one of the ingredients of TCP, which is P. Now, that does not make any sense to me. And I don't think that reflects what courts actually do. I don't think that our minds operate in that fashion. So what does it mean? Well, I'm not really sure what it means. I don't see any way out of it. Some people have tried to explain or rationalize this by saying, well, when you do ordinary interpretation, it's a small p that you're using, right? You don't give much weight to purpose when you're doing ordinary interpretation. But when you get to the GAR, then what you're doing is you're doing a big P. You're giving a lot of weight to purpose. And all I can say is, I don't see anything in the cases that I've read from the Supreme Court that indicates that's what they're thinking. And even if it was, say, well, what justification is there for that? Like, why? Okay. And then he basically adopts the same tests for abuse that were adopted in Canada Trust Co. and then confirmed later in Copthorne. He disagrees with Cote's dissent, which I'll talk about in a minute, because her dissent, this particular aspect of her dissent, relates to what we just talked about, and it's an insidious way to basically render the GAR completely meaningless. So he then basically says what the object, spirit, and purpose of 111.5 is, and I have no quarrel with what he basically says there. I think it's pretty difficult to disagree with that analysis. And then he makes a bit of a misstep by saying de jure control is a rough proxy. And that I don't understand, but I mean, a proxy is something that stands for something else, right? So I don't know what de jure control is a proxy for. That's the difficulty with that. And then there were, in the lower courts, they talked about effective control and actual control. And he basically says, and I think he's right, those are confusing. Right? Best not to talk about those. Right? Unfortunately, as we'll see, he then says something that I think just exacerbates the confusion. And he fundamentally looks at the transactions and says, and he looks at them and views them, I think, quite realistically, and concludes that, yes, they violate the object, spirit, and purpose because the continuity that's required by 111.5 in terms of its rationale, which is the business has to continue, the shareholders have to continue, right? That those have been frustrated or defeated. And then he says, right, this idea of functional equivalent of de jure control, that the transactions were the functional equivalent. And I mean, I just think it's best to treat that as a slip of the tongue unless some subsequent court makes something out of it. I know tax practitioners have been very critical of this aspect of the case because they say, well, this is introducing a new test. So substituting, rewriting the provision, right, to substitute a new test. Right, which is not de jure control, it's de jure control plus functional equivalence of de jure control. So I think that was unfortunate that he said that. I think the best way to read his decision is, no, the test is de jure control. Right, that's pretty solid, I think. And that's not a bad thing because that provides taxpayers and tax officials with certainty. Right? We know what de jure control means. We can determine whether it applies or whether it doesn't apply. But then what does the GAR do? The GAR does what we all know the GAR is intended to do, which is it comes in and says, yes, but you cannot abuse de jure control. And if you do, we have this rule here. And the rule says, no, if you defeat the rationale of 111.5, then the GAR will stop you from doing that. And that, to me, makes perfect sense. It doesn't turn de jure control into a de facto control test. It simply says you can't abuse provisions. Just briefly, because it's a lone dissent, so it's not as significant as a dissent that involves a number of other judges on the court. And the dissent, I think, is just a bit extreme, and that undermines its credibility. I mean, she says, this case is of profound concern to Canadians. I encourage you all to go out to your neighborhood pub tonight and ask people there, right, how they feel about the Dean's Knight decision, because it's profound concern to all Canadians. It's ludicrous, isn't it? It's not a profound concern. Most people say, Dean's Knight, what's that? So what she does then is she says, well, this is an ad hoc approach, right? So it just means that the courts are going to apply the GAR whenever they feel like it in cases. Unbounded judicial discretion. You see, each and every case, this is just hyperbole. It's just not reasonable. And she makes the kinds of comments that we've come to expect. GAR can't override Parliament's specific intent. Think about that. So you've got specific provisions, and Justice Cote is gung-ho to look at Parliament's intent in those provisions. I've always understood that the GAR was one of Parliament's provisions. But when it comes to the GAR, she's not so gung-ho at looking at Parliament's intent. She only wants to concentrate on Parliament's intent in the specific provisions. Why? GAR can't be used to rewrite provisions of the Act. Well, of course it can. I don't know anybody who argues that it can be. But that doesn't mean, does it, that the GAR can never apply, or it'd be meaningless. This is the point that I want to just for you to note, because it relates to this issue about how the application of the first step in the GAR is related to statutory interpretation. And I must say, I had been dreading this argument coming up. I thought it would, and here it is, right? So she says, well, right, this abuse analysis under the GAR, it's a specialized form of statutory interpretation, right? And then she says, it can supplement specific anti-avoidance rules. She concedes in principle, but it can't do it where the specific anti-avoidance rule is drafted in a technical, careful manner. And can you imagine that there are any specific anti-avoidance rules in the Income Tax Act that aren't drafted in a technical, careful manner? Because I can't. I mean, that's not, the Department of Finance doesn't do things haphazardly. They think seriously about these things. So basically what she's done is she's framing this issue, right, in a rather biased way. What she's done is, if you know the basic approach that the Supreme Court has adopted for the interpretation of tax provisions, they say, oh, it's TCP, right? But because tax provisions are precise and unequivocal, the text will be the dominant consideration. What she's basically doing is she's saying, well, if that's good for an ordinary exercise in statutory interpretation, I guess it must be good for that first step in the GAR analysis. And fundamentally, right, the argument will be that text captures the purpose, the underlying rationale of the provision completely, and as a result, if a transaction complies with a section like 111.5, then the GAR cannot apply to it. It's that simple. So it renders the GAR meaningless with respect to specific anti-avoidance rules. Okay. The other thing is that, and we talked about this, I mean, this came up in the hearing as well, this idea that section 111.5 represents a binary choice between de jure control and de facto control. And she says, well, Parliament clearly rejected de facto control. But those aren't the only two choices, 111.5. As I indicated, seems to me what the GAR does is it supplements de jure control. It doesn't supplement it by substituting de facto control. No, it just it doesn't substitute. It supplements de jure control and says, right, if you acquire de jure control, the provision applies. If you don't acquire de jure control, the provision won't apply unless you do it in an abusive fashion. And then it will. Okay. So, just to conclude on Dean's Night, as I said, to me it doesn't represent a significant shift in the Supreme Court's GAR jurisprudence. It basically confirmed fundamental aspects of the application of the GAR to transactions. But what it may signal it has to do with the composition of the court. So you go back to Alta Energy. You may remember in Alta Energy, it was a 6-3 decision. The 3 dissenting judges saying that they would have applied the GAR in that situation. 6 in the majority, 2 have since resigned. Well, they had to retire. And they've been replaced by 2 justices who sided with the majority in Dean's Night. So, doing a little bit of arithmetic, right? The majority of 6 has been reduced by 2, so there's only 4 of them left. Right? And the 2 that replaced them sided with the 3 dissenters in Alta Energy. Plus a couple of others moved from applying the GAR in Alta Energy to not applying the GAR in Alta Energy to applying the GAR in Dean's Night. So that shift on the Supreme Court may suggest that the court is in the process of adopting a different attitude to the GAR, not substance in terms of how the GAR applies, but it's just their attitude to the GAR may be different. And of course, Justice Brown has resigned, right? We'll see who his replacement is. But, you know, I think that if I was with the CRA or the Department of Justice, I would be feeling pretty good about the way things are looking. So just a couple of words about the proposed amendments and how they relate to what went on in Dean's Night. So, first of all, Finance didn't wait for the decision in Dean's Night, which is surprising to me. We'll see if they make any revisions in the light of the Dean's Night decision. For example, a number of people are saying the amendments aren't necessary because of Dean's Night. I don't agree with that, but that's what a number of people are saying. So here are the things that it does. We're going to get a new preamble. They're going to change the principal purpose test to a one of the main purposes test. We're going to get new economic substance rules. We've got a penalty, which of course you're familiar with here in the province of Quebec because the provincial GAR has a penalty attached to it. Although you can see the Quebec penalty is quite a bit more serious than the proposed federal penalty, which is 25%, whereas Quebec learned when it first adopted a 25% penalty and then said, hey, that's not enough, and increased it to 50%. So let's just look at the preamble, because it's interesting because it's so new. We've never had anything like this before. Right? So this is a preamble, not a preamble to the statute, which is typically what preambles are. If you go and look at the Charter of Rights and Freedoms, right, you'll see there's a preamble at the beginning. This is a preamble just to the Guard. It's going to do three things. First one is it just describes what the Guard does, right? And then it's accompanied by this, it says it denies abuse of tax benefits. And then it says, while allowing taxpayers to obtain benefits contemplated by the relevant provisions. And I must say, that's not what the Guard does. The Guard denies benefits. It doesn't allow benefits. So I'm not sure what this is after, but doesn't seem to me it's that important. The second one is important because it goes to that mantra about taxpayers' entitlement to certainty, predictability, and fairness. Right? Notice the difference in wording here, because what the Supreme Court talked about in Alta Energy is taxpayers' right to certainty, predictability, and fairness. This talks about taxpayers' need. There's a big difference between a need and a right. So this says that need for tax certainty, right, must be balanced against the government's responsibility to protect the tax base and ensure fairness for all Canadians. So you can see this is pretty clearly an attempt to nudge the Supreme Court away from so much reliance on that mantra, right? Trying to nudge it away from considering certainty, predictability, and fairness to be a foundational principle of our tax system. And by the way, I mean, why would the Supreme Court be wanting to protect tax avoiders' right to fairness? Like, why do we have to be fair to people who are trying to rip off the tax system? I just don't understand that. We don't need to punish them needlessly, but fairness is about fairness to all of us. The real question here is, how effective is that going to be? And, I think if you've read Justice Cote's dissent, you know that she's not going to be persuaded by this statement in the preamble. Whether other judges on the court are going to be, I don't know. But I can't imagine a judge who comes to the conclusion that the Guard doesn't apply is going to change his mind as a result of this sort of airy-fairy motherhood statement in the preamble to the Guard. And then the third thing is, just trying once again to dispel the notion that the Guard can't apply to strategies, tax planning strategies that Parliament foresaw. Is that necessary in light of what the Supreme Court said in Dean's Night? Well, if I was with the Department of Finance, I'd say, well, maybe not. But they've changed their minds before. So what harm does it do? And it doesn't do any harm to clarify it. This is the economic substance provision. We don't have time to discuss it in detail. It's also a very novel provision. because it's what I call a double tendency test. In other words, if a transaction lacks significant economic substance, that tends to indicate that the transaction is abusive, according to the court, right? I guess. Right? So tends to indicate, not necessarily, but it tends to. And then, well, when does a transaction significantly lack economic substance? Well, there are a bunch of factors that tend to indicate that it lacks economic substance. So you got this double tends to indicate test. Now, I think judges are going to be puzzled about what this means and how do they apply it. But I can understand what finance is grappling with, right? And they don't want to go all the way to saying, right, look, if funds go around in a circular fashion, that's an abuse because it lacks economic substance. If it lacks economic substance, it's an abuse. So they don't want a firm rule like that. They want to build some discretion for the judges into the rule, right? But they don't want to go, right, to what I think is a better approach, which is just list the factors. List a bunch of factors in the provision and tell the courts that they have to consider them. Don't tell them what they have to conclude on the basis of the factors, but just say, well, look at these things. Because we think if you look at them, right, that will assist you in making a more robust decision. The other thing I don't like about this is the third part, right, which is the factor that tends to indicate a significant lack of economic substance is if the purpose of the transaction was entirely or almost entirely to get the tax benefit. This is mixing the purpose test, which applies for purposes of the avoidance transaction, and the abuse test under 245(4). I think that's just going to complicate things unnecessarily. The final thing that I would just mention here is that this penalty, I think it's pretty reasonable. 25% is too little. I've been arguing for a penalty since I was a consultant to finance during the GAR analysis, the development of the GAR. I think you need it in order to provide some deterrent effect. And I like the fact that if the taxpayer discloses, right, pursuant to the new mandatory disclosure rules or voluntarily, then the penalty's not on. But the thing that you want to think about this that doesn't make any sense to me is if the transaction involves a tax attribute. So, you know, tax benefit is a reduction, avoidance, or deferral of tax, right? So what do? You do a transaction and it increases a tax attribute. That's the whole problem that the 2022 amendment was intended to deal with, right? That there's no tax reduction. If all you do is you increase your capital dividend account, you increase your paid up capital, but you don't pay a dividend, there's no reduction of tax. The amendments in 22 dealt with that. What they're saying here is, if that's what you do, there's no penalty. That does not make any sense to me. I know it's a bit harder to calculate the amount of a penalty where you've only got an increase in a tax attribute. But this to simply say, so you don't have to pay anything at all, just doesn't make sense to me. Right? And I have no doubt that in the fullness of time, if that goes ahead, it will be exploited by some very smart people. Questions? Comments? I suspect that you are probably more confused than you were before I started talking. But I can only hope that you're confused at a higher level. Thank you.
Est-ce qu'il y a des questions dans la salle? Je ne sais pas si à Sherbrooke, il y avait des questions.
I would just like to say that if they did not understand the importance of reading the tax cases with your analysis, I think they now understand it, that they need to read the cases. There's a lot behind all those words in the tax cases, and you cannot just look at summary and say, okay, this is the principle of that case. So, thank you very much for that.
Regarding all this, how do you think the CRA would interpret this that is regarding game nights? And we have the amendments that they're doing right now. We didn't have time to go through it, but they like switching the burden of proving if it's abusive or not to the taxpayer instead of them. How do you think they'll react? Do you think there can be some abuse from them, if you want to say the abuse thing?
I doubt it. I doubt it very much because that's another thing we didn't get a chance to talk about. But the court reaffirmed the fact that the burden for showing abuse is on the government, and that the abuse must be clear. And I've never understood that. I mean, why would the government, right, whether you think the burden should be on the government or not, but why does it have to be clear? And like, it seems to me that's sort of like a criminal law burden, right? Like beyond a reasonable doubt. And I don't understand why, if it's not just the ordinary burden, which is on a balance of probabilities, right? This is an abuse. But so I think those two things in combination will allay any fears that you have that the CRA is going to be abusive.
If I may, I have a question about the economic substance test. I know that you have an international expertise. So did you see in any other country this kind of test in the anti-avoidance provision, and does it work?
A number of other jurisdictions have much more detailed rules about economic substance. So if you look at the United States, I mean, they codified their judicial economic substance doctrines probably 10 years ago. If you look at the South African GAR, which, by the way, has copied our misuse or abuse test, but you will see what they have done is they have very detailed rules. So you know that circular flow of funds that, you know, just those 4 words are put in our proposed rule. In the South African rule, that goes on for about a page. They call it round-trip financing. And it's quite detailed rules. And they have other rules with respect to economic substance as well. So yes, they do, and I think, yes, they've been reasonably effective in directing the court's attention to the importance of those issues. I think the problem with our GAR and the courts is that I sort of expected that the courts would create those kinds of rules with the GAR, but they haven't. And I think that's because, you know, those judges on the Supreme Court, they're not tax people, right? They're generalist judges. So they don't know a lot about these kinds of things. And they need some direction. But But I would have thought that if you're trying to decide whether or not a transaction is abusive, you look at those kind of factors. You know, if the money goes around the circle, I'm not saying obviously, but just you need to direct their attention to it. And if the taxpayer cannot possibly profit from a transaction, doesn't that tell you something? It tells you that, you know, well, maybe we should really contemplate whether or not the taxpayer is just doing this to get the tax benefit. That's an indication. But the courts haven't come up with those kinds of objective criteria to apply. And that's the difficulty with just saying abuse. What does abuse mean? Tell me, doesn't give me any test that I can apply to determine whether something is abusive or not. And that's what I think these factors that finance is considering, right, are important to give the court some objective factors. The difficulty is what it does with them because of this tends to indicate.
So we'll see how the courts apply this new test. I know that you don't have a crystal ball, but do you feel it's the first step towards something more drastic or strict, or just something that is left to the court, and we'll see what we will do?
I mean, that's the tragedy of any general anti-avoidance rule, right? Is that who gets to interpret it? It's the courts. So, I mean, you look around the world, you can see, I mean, that some courts in some places have taken very strongly worded general anti-avoidance rules and decimated them. And other courts have taken rules that are broadly big and turned them into potent anti-abuse rules. And so, yeah, it's left up to the courts, and that's going to swing back and forth. You know, it's not going to all be one way. You know, there's a friend of mine who worked on the GAR with me said, you know, like, even if the CRA and the Department of Justice are very conservative, so that they don't take any GAR cases to court that they don't think they've got like an 80% chance of winning, the courts are never going to let the government win 100% of the GAR cases. It's just they're not going to do that.
Other questions?
No questions in Shelbrook.
Okay. So on these comments, we're going to conclude our discussion today. I would like to thank you very much. These concepts, I mean, the GAR is very complex for everybody, maybe except for you. But you really help us to understand sometimes like Lynn said, in the case, in the judgment, we read some aspects and we don't get the sense of it at first. But with your help today for these nights, we really now see it in a different way, and then we'd like to thank you very much for this. Thank you. So, merci beaucoup. Merci. Thank you, everybody, for being here today. And thanks again, Professor Arnold. Thank you. Thank you. See you soon.